In September of 1787 in Philadelphia, there was a draft of a Constitution of the United States of America that had been approved by the delegates at the convention. Now it was up to the states through their own conventions to decide whether or not to accept or reject this replacement for the Articles of Confederation. Basically, there were two camps that developed. One became known as the Federalist Camp, which supported the Constitution and a stronger national government. And the other was the Anti-Federalists, which rejected the Constitution for various reasons, but one of the strongest reasons had to do with the fact that there was no Bill of Rights contained in the 1787 draft. Interestingly enough, one set of writings affected the debate in the Constitution, over the Constitution, and these were writings that were initially put in New York newspapers, writings by Alexander Hamilton, James Madison, and John Jay. These became known as the Federalist Papers, and basically it was an attempt to explain what were we trying to accomplish there in Philadelphia. And this became a very popular read, and many, many copies of these Federalist Papers were circulated and widely read. The idea behind the conventions being used to ratify the Constitution, that is, approve it for as the law of the United States, was really the idea of having the people, rather than just the politicians, decide this issue. And so it was more of a direct method by which people would have a voice in whether or not the Constitution was approved. And ultimately it was. After much debate and some close calls and so forth, the Constitution was approved. What was interesting, and this is probably why it did get approved, it became clear that even many proponents of the new Constitution felt there should be a Bill of Rights. And so it was that the legislature set about, this new legislature under the Constitution of the United States of America, set out to make a list of liberty rights and approve them to be part of the Constitution. This is known as the Bill of Rights. It's the first 10 amendments of the Constitution. It deals with so many differing rights. The First Amendment with things like freedom of the press and freedom of speech and the free exercise of religion and no establishment of a state religion. The right to petition the government for redress of grievances, freedom of assembly. And so you have all of these rights just in the First Amendment, these expanded political rights that allowed people to gather together, to protest, to be heard, this sort of thing. Very powerful stuff. The Second Amendment, interestingly enough, was an oversight, was correcting an oversight that existed because the Constitution didn't really talk about the militia. What about the militia? What was going to be the military? You see? And so the Second Amendment, of course, established it by implication, of course, but there was going to be a militia, and that the people would have the right to bear arms. Of course, a very controversial liberty right granted by the Constitution in this day and time. But nevertheless, it was tied to the militia, but guns became part of the American way, in part because we went through so many years where we had a frontier. You know, you had initially the 13 colonies, and then you had the Louisiana Territory, so you had a new frontier. And out there wasn't much law and order. You needed firearms to hunt, to protect yourself, and so on and so forth. And then we had another frontier and another frontier. And then finally Alaska, our last frontier, if you will, in the 20th century. So guns had become part of the fabric of the country, as well as supported to some degree in the Constitution. There were a number of liberty rights that were designed to protect people from the criminal justice system of the government. These were very critical rights. Most of them had been developed by the British. The Writ of Habeas Corpus, which meant that you could apply to have the government ordered to produce someone held, to bring them into court, to show why you were holding them. Very important thing, which was started with the British. So you had the Writ of Habeas Corpus. You had the notion of not being required to incriminate yourself, freedom from self-incrimination, a protection from double jeopardy, which is interesting. The idea you can't be tried twice for the same offense. Well, you know, the thing is that so many of our liberty rights are affected by interpretation by the Supreme Court, and we'll get to why that's the case later. But the fact is that it appears that this matter is going to be addressed again by the Supreme Court of the United States, and so far they have supported what they call dual sovereignty. In other words, if the transaction in question is from the same events, and it creates a federal crime and a state crime, well, that you may be subject to being tried twice for the same offense, once by the state sovereign and the other by the federal sovereign. At any rate, you had the double jeopardy protection inserted into the Bill of Rights. The right to reasonable bail. And of course, bail means a pledge of money or property to secure your appearance at trial in a criminal case. It was also put in there that there shouldn't be unreasonable fines put into place. Now you get these terms and you wonder, where do they get the dollar amount? Well, that's what the courts are for. You had the right to counsel, and the accused did. The right to subpoena witnesses in the defendant's behalf, what they call compulsory process. The right to trial by jury. The jury deciding the facts of a case, and those facts, that decision normally not to be disturbed if it was an acquittal. And so this infusion of liberty rights to protect the criminal defendant became a hallmark, of our Constitution, because it has to do with the power of government to prosecute you with all its resources. What protections do you have? The Constitution basically established the structure of the government, the three branches of government. What were the qualifications for office? It was specifically stated in the Constitution that there would be no religious test in order to hold office. So the idea was that these requirements were to be neutral and not discriminatory, if you will. So, the Bill of Rights, the first 10 amendments, created lots of additional protections. Now, there's some that people aren't as familiar with that I want to mention. One is that there's no title of nobility permitted per the Constitution of the United States of America. You know how that the Queen knights people, like Sir Elton John, Sir Sean Connery, that thing, where they get a title? You can't get that in the United States. You want a title, you got to go buy one from Europe, okay? Not permitted. They also don't permit, the Constitution does not permit what are called bills of attainder. And a bill of attainder is where legislation is created, whereby the legislation itself, by the way it's worded, convicts you, sanctions you in some way. See, so for example, let's say you had a statute that said that no person may operate a gun store if the person has ever been indicted for a felony. Well, that's a bill of attainder. The indictment means a charge. And so by punishing you, they're punishing you without you having due process of law, fair notice of the charge, the opportunity to be heard, the right to be tried by a court before you can be sanctioned for a crime. If you can just be sanctioned based on the legislation plus the allegation, that's a bill of attainder. There's a liberty right dealing with the government taking your property, what they call eminent domain, where the government seeks to take someone's property for public use or benefit. The Constitution, while it allows it, requires just compensation, fair compensation, if you will, if they engage in that taking. We'll take a break now, and then we'll come back and we'll finish up the discussion of the various liberty rights.